Hello, great people. Welcome back to our channel. We're so excited to have you again. Nnamdi Kanu's trial on 21st of October 2021 has landed both the Chief Judge of the Federal High Court and DSS in trouble. And this time around, you are going to hear the set of people who have dragged them to court over their attitude towards them during the trial. We're going to be looking at full details of these and also consider some implication that this will have on the DSS and also on the Chief Judge. But before we give you full details of these, we'd like to encourage you to please subscribe to our channel by clicking on the red subscribe button and also the bell icon so that you get notification anytime we publish our news. Now, according to the news, a human rights lawyer, Tobe Temokun, has filed a lawsuit against the Director General of the Department of State Services, the Inspector General of Police, as well as the Chief Judge of the Federal High Court for their rules in restricting journalists from covering the trial of Nnamdi Kanu, leader of the indigenous people of Biafra IPOB. The plaintiff filed a suit at the Federal High Court in Abuja, the same court Kanu is being prosecuted on charges of treasonable felony and insurgency. The charges, according to the prosecution, arose from Kanu's separatist agitation for a republic of Biafra constituted by Igbo-dominated southeastern part of Nigeria. According to Premium Times, Temokun cited in his suit, which he said was instituted in defense of press freedom, how only a handful of journalists were accredited on July 23 to cover the July 26 proceeding in Kanu's trial, while many unaccredited ones were barred from accessing the courtroom. Since Kanu's first court appearance in June after he fled the country in September 2017, the court management and security operatives have been restricting media coverage of the case that attracts local and international interest. Temokun noted in his suit that the circular dated July 23, 2021, titled Media Accreditation for Nnamdi Kanu's Trial, which allowed some selected journalists to enter the court premises and denied others not selected entry, amounts to a breach of the right to freedom of expression and the press guaranteed by the Nigerian Constitution and African Charter on Human and People's Rights. He also argued that the act of the officers and or operatives of the SSS and the police of condoning of or barricading the access route to the entrance of the Federal High Court in Abuja on July 26 and allowed journalists whose name were contained in the July 23 circular amounts to a breach of the right to freedom from discrimination. In a ridiculous repeat of the media restriction, DSS operative complemented by the Nigerian Police Force and the Nigerian Army on Thursday barricaded adjoining streets to the Federal High Court in Abuja, the venue of the trial, turning journalists and lawyers away from the surrounding of the court premises. Announcing the suit which he filed on October 18, in a statement on Friday, Temokun said that the indiscriminate harassment and assault of journalists and lawyers was a violation of their constitutional guaranteed right. Denying journalists access to the courts is an indictment on any democracy because in true democracy, press freedom comes first. The lawyer said it has become necessary to challenge this new regime of repression enjoying judicial support. According to him, he said, I have resolved to challenge this circular and have filed an action in the Federal High Court Abuja today, suit number FHC ABJCS 1272-2021, subjecting the legality of this repressive document to scrutiny. The barrister added that security agencies had relied on the journalist accreditation circular that was issued by the Federal High Court to molest and threaten journalists and members of the public, including Omoyele Sowore, the human rights activist. Temokun implored the court to issue an order of perpetual injunction restraining the defendants or through their representative agents or privies or anybody or anyone acting under the authority of the defendants from giving any or further effect to the circular. Temokun also urged the court to issue an order of perpetual injunction restraining security operative of the DSS and the police from further restricting and or preventing media houses and journalists from entering court premises based on the circular. The Director General of the DSS, Inspector General of Police, the Chief Judge of the Federal High Court, and the Court Information Officer who signed the accreditation circular, Catherine Christopher, are listed as respondents. This issue of Nnamdi Kanu's case has, erupted a lot of things, such that it's becoming almost a thorn in the flesh of, the DSS, the federal government, virtually anyone that is connected to it. And, the issue of freedom of press is very important, because whenever you allow them to come into any situation, you can be sure to get the right information, and it's a way of curtailing people not to do things just anyhow. You understand? I could still remember when Ifeanyi Ubah, he said that on that particular day that Nnamdi Kanu had a case, was the same day he had a case, but by the time he came, the whole place was barricaded. Yeah, we know, because I know that what the police will say is for security reasons, because of fear of ESN and the likes. I think even that's one of the reasons why they did not grant his request of being moved from DSS custody to Kuje prison, because the management of Kuje prison had already complained that they do not want any form of attack because they don't have the capacity to withstand the attack if it comes from, ESN and all of that. So I think that is one of the things that they are going to put forward for being the reason, why they cannot allow everyone access to it. But looking at the situation thus far, just like one of the journalists who was in the company of Ifeanyi, Ubah rightly say, the courtroom is actually the marketplace for lawyers. And the duty of journalists or anyone who is interested in this case, based on the arrangement of the court, oftentimes is not being restricted, because they are coming in also to be witnesses to how the judge carried out the case. Some are coming in to learn. Some is their marketplace, so they have the full right to stay there. So I don't know if in the Constitution they are going to start profiling some case, that if a case like this comes up, people are being restricted from coming in, or if there are exemptions, that are meant to be put in place to restrict people. Because I know that this case, certainly when it comes up, the person who, roll it out is sure to win, because everybody knows that journalists should have that singular right. Any Nigerian, not just journalists, any Nigerian have the right, especially when it comes to the issue of cases like that, to be there. Anyone who messes up will be forced to pay some bill. All what was expected, personally, what I was expecting was that DSS will be well positioned, and everything will be in place. Logistics will be in place. The police will be on ground. No harassment, everybody can look, and then, but if you intend to go in there and foment trouble, they will deal with you. Just like what happened. I could still remember the DSS guys arresting some guys who came to, fight or attack Sowore. If you had watched that video, is there where some guys just came in and they started harassing him and all of that. So that should have been their responsibility. Anyone who wants to break law and order in the court will just be arrested immediately. But preventing people from going into the courtroom is quite questionable. And the lawyer has taken them to court. Let's see how it would turn out if in the next sitting, all the journalists will be given free entry into the courtroom. That's where we like to leave it. Go to our comment section. What's your position on the restriction that was put against the lawyers, put against the journalists, and also the members of the public? Do you think that the reason